Court does call the case of Arbor Commercial Realty versus Scott Sendes.
Good afternoon, Your Honor. For the record, Tim Dabalski appearing on behalf of the plaintiff, Commercial Realty, LLC.
Scott Sendes, Your Honor.
All right. And where are we on this, John?
Well, I thought we were going to be able to resolve this, but we were unable to. So I guess we're going to have a hearing, Your Honor.
So what's the issue?
Well, I'm not really quite sure. The tenant wants 6 months to move all of the stuff out. That's one issue. And I told him that we can't provide him 6 months. We can give him a little bit more than the 10-day statutory period. And the other thing is that he feels for one reason or another that there was an agreement that if he moved out, which he still hasn't moved out, that he didn't owe any back rent. Did I accurately?
Correct.
Those
Yeah,
are.
we had a verbal agreement that.
This case shows how informal agreements often lead to disputes, especially when no clear contract exists. The tenant believed a gentleman's agreement was made, but the landlord denies it. This is a classic verbal contract conflict. The judge wisely decides to split the case into possession and monetary issues. Focusing on possession first makes sense. It allows the court to address the urgent matter of who controls the property before money disputes. The tenant's request for 6 months to move out is a key point of tension. Landlords usually want faster possession to avoid losses. This case highlights how unclear communication can cause prolonged legal battles.
I was to move out, that I would no longer be paying the rent. I told him I couldn't pay the rent and move out. And I thought we had come to a mutual agreement that it would be best for both parties if I just moved everything out.
And it's my client's position that no agreement was made. And even if one was, the client still hasn't moved out and still wants another 6 months to move out, Your Honor.
So you're not disputing that the rent's owed, right?
Well, I am, because I had an agreement with the landlord to, if I moved out, in lieu of paying the back rent.
Which he hasn't moved out, even if there was an agreement. Your Honor.
But I'm in the process of moving out. It's
But
Really, guys, I hear you. You guys can keep repeating it, but I can.
I'm sorry, Your Honor.
From one moment to the next. I get it. So, I mean, there are two parts, so that you understand this, sir. There are two parts of this case. One is the possession issue, and then the monetary issue. In terms of the possession,
The judge's decision to bifurcate the hearing is smart and practical by separating possession from money owed. The court can expedite eviction if necessary while still allowing the tenant to contest back rent later. The tenant's argument about a verbal agreement not to pay rent if he moved out is tricky. Verbal contracts are often difficult to prove in court, especially when ownership changes mid-case. The tenant learning that the person he dealt with no longer owns the property complicates things further. It's a reminder to always verify the authority of the person you're negotiating with. This case also shows the challenges of dealing with large commercial spaces full of inventory. Moving out is not as simple as packing a few boxes.
I don't see that there's an issue for me to try, because the condition of you staying is, first of all, to pay rent. Even if, I'm not saying that I'd make a finding that there is, even if there is this other agreement that you move and you don't owe the rent, the only bearing that has on the possession issue is you were supposed to move, right? So I can bifurcate the hearing so that we deal with just the possession issue and then set it for a further hearing as to the money claim. But if I do that, then the question is when are you going to move? Because I think they'd be entitled to a judgment for possession. And the reality is that if I do that, finding no tribal issue on the issue of possession, it's going to be 10 days. I can tell you that even using my discretion, I wouldn't give you 6 months to move. So if we just deal with that part of it, when can you be out?
I mean, I said realistically 6 months because there's so much stuff. I understand that that's not agreeable with them, but I've tried to work with them. I even offered another solution to conduct a liquidation auction, but I said even that's going to take, probably 2 months realistically, and everything still won't sell. So I did make a promise that I would clear the property out in lieu of not paying rent, that I would make sure that it was, left empty. And that's why I came up with the 6 months, because I know that's still going to take time. Even after I liquidate a vast majority of the stuff, it's still going to take time to remove the junk. And I'm willing to pay for the removal of all the trash that's in there and leave it empty. But I don't think that's agreeable.
Well, they've said it's not agreeable.
The other problem I'm having is I just found out recently, a few minutes ago, that the person I've been dealing with apparently is no longer the owner of the property. So the person that I've been dealing with, the person that I had a verbal agreement with, I guess is no longer, making the calls. And I was not aware of that, which I guess explains why I haven't heard back from the person that I had made this deal with, because I just found that out a few minutes ago.
Well, Your Honor, speaking to that aspect only,
The tenant's willingness to pay for removal of leftover junk and conduct a liquidation sale shows some good faith effort, but the landlord and court understandably prioritize timely possession. 6 months is a long time in legal terms, especially when statutory rules often require faster resolutions. The judge emphasizes that even with discretion, 6 months won't be granted. The tenant's situation is tough, but courts must balance fairness with legal standards. This case highlights how lengthy eviction processes can be for commercial tenants and how courts strive to enforce rules while considering real-life challenges. Communication breakdowns here caused unnecessary delays and confusion, which is a lesson for both landlords and tenants.
the owner, the son has been managing the property for the last year or so. So I don't know I think that's what you're referring to,
I
correct?
guess I just meant I wasn't aware that the person that I was talking to isn't actually running the operation anymore. So when I was told, I won't charge you any rent if you can move everything out, and at the time I talked to him last, I didn't give him a time.
That's, again, the problem with that is, if I assume that's true, you haven't moved.
I'm in the
Which
process.
means if you haven't moved, that means you still owe the rent, right? Which means they'd be entitled to a judgment and you'd still owe the money.
But the agreement that I had was that I wouldn't be paying anymore if I moved out.
But you haven't moved out.
Correct. I'm in the process of moving out.
Well, according to his own words, Your Honor, that's a 6 months ordeal. So, I mean, I could say I'm moving out of my house by taking a dish at a time.
Well, this isn't a one bedroom apartment. This is a 10,000 square foot warehouse packed to the rafters with stuff. So it's not, it took several years.
I get back to my same question. For you, how much time are you looking? 6 months is not going to happen.
Okay.
So here, just let me finish this. The statutory.
The confusion over summons delivery adds another layer of complexity. The tenant didn't receive proper court notification, showing how procedural issues can impact legal proceedings. The summons taped to the door, but with the wrong courthouse address, caused missed hearings and misunderstandings. Proper service of process is essential to ensure fair hearings. Courts rely on proof of service, but it must be accurate and timely. This procedural snag delayed resolution further and could affect case outcomes. It's a good reminder that all parties must ensure paperwork is handled correctly. The court appears patient but firm, reminding parties to follow rules to avoid penalties. Procedural diligence is critical in legal disputes.
10 days.
Right.
I get the circumstance that you're in, so maybe that's not realistic that it's a 10 days.
Right.
But I can tell you that even if I use the furthest reaches of my discretion to give additional time, it's not going to be near 6 months.
Okay.
And so if you guys can't decide, I'm going to pick a date on the possession issue, and then I set it for trial on the monetary issue. But you guys are going to have to decide. It's going to have to be something realistic, sir. I mean, they're entitled to the possession of their property by even what your agreement was. They're entitled to possession.
I mean, I can guarantee I can't move everything out in 10 days. It's not.
How much, what would be the fastest?
I mean, 4 months, is that agreeable?
No, that still puts us in the same position.
It's, like I said, I've probably moved half of it out within the past, 3 months. It's gonna take, I would say, at least 4 months, realistically.
I mean, no.
We'll let Your Honor make that decision.
That's really don't want me to do that. Nobody gets happy then. But what's the trial date deadline? Thank you. Listen to everybody. As to the issue of possession, I'm going to find that there's no tribal issue as to the issue of possession only. I'm going to issue an order of eviction on or after June 30th.
After what, June 30th, Your Honor?
Yes, June 30th.
Thank you very much.
I will also, on the monetary, on the damages and money issues on the case, I'll set a trial on that matter for July 15th, 2025 at 9 a.m.
Thank you. And I will prepare the order on the possession. I'll submit it to the court. I'll submit a copy to you.
Will I be getting a copy? Because that's the other thing. I haven't received any court summons or anything.
Well, we have a proof of service in the file, Your Honor.
What do you mean you haven't received any summons?
The only summons that I received was the one on that was taped to the door, and
Well, that's service.
I was under the impression that I was also supposed to be mailed something as well. The one that was taped to the door had the address in Saline, which is why I wasn't here at noon, because I went to the courthouse in Saline and they said, "Oh, you're at the wrong place." And then I called the number that was on the summons, and the number was for Wayne County Courthouse. So my summons that I received on the door was little.
So what do you want me to do with that? You're here. I've heard your case.
I'm just saying, am I going to receive
Yes,
mailing?
I'll tell you what. Here's what we'll do. You'll get a judgment. Prepare a judgment. I'll sign it, and I'll give you a copy. Thank you.
The judgment up at the counter.
Yes, get a judgment out at the counter, sign it, and then...
The confusion over summons delivery adds another layer of complexity. The tenant didn't receive proper court notification, showing how procedural issues can impact legal proceedings. The summons taped to the door, but with the wrong courthouse address, caused missed hearings and misunderstandings. Proper service of process is essential to ensure fair hearings. Courts rely on proof of service, but it must be accurate and timely. This procedural snag delayed resolution further and could affect case outcomes. It's a good reminder that all parties must ensure paperwork is handled correctly. The court appears patient but firm, reminding parties to follow rules to avoid penalties. Procedural diligence is critical in legal disputes. And thanks for watching this video, guys. Bye, take care.